see. All right. Hey, everyone. It's right at 5:30. So let's go ahead and get started. My name is Rachel Mills, and I work with the Louisiana State Bar Association. Welcome to our Law Talks virtual workshop series. Tonight's Law Talk is on landlord-tenant issues, and we have Greg Landry here today presenting on this important topic. Greg, do you mind advancing the slide? Before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end if time permits and answered live. If you're watching at a library, you may walk up to the computer to ask or submit to the library staff. If you're watching via Zoom, please submit questions in the Q&A section. If you're watching via Facebook, please submit questions in the comments section. Please note that these comments are public and accessible by anyone during and after the presentation is over. Let's see. So just a couple disclaimers for you guys. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator. Further, the LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that these presentations or materials were free of errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its section, or committees. Views expressed are those of the author and contributor only. As mentioned today, our presenter is Greg Landry, former Executive Director of Acadiana Legal Services. He's a graduate of Paul M. Hebert Law Center. He has 40 years of experience practicing public interest law, and he's thankfully a volunteer with several organizations now since he's retired. So one more slide.
I see there's a slight lag between when I change slides and it pops up on the Facebook feed.
Yeah. Let's see. So if you are looking for free legal help, you may consider reaching out to the state's two civil legal aid programs. They are Acadiana Legal Service Corporation and Southeast Louisiana Legal Services. They only provide civil legal information, so issues like tonight, landlord-tenant, divorce, child custody, public benefits, and those kind of matters. You can find their websites on this page, but also feel free to give them a call. And from here, I'm just going to turn it over to you, Greg.
All right, great. Thank you, Rachel. If you are able to, please enter into the chat or the comments what town you're in so I can get an idea of how far abroad across the state we're covering this evening. Okay, I'm looking. I see a few. All right. I noticed too that there's a little delay between when I change screens and it catches up on Facebook. So I'll pause a little bit on those changes to make sure that what you're seeing on the screen matches up with what we're talking about. All right. I guess we should start with a couple of hints about terms that you're going to hear. Louisiana is a civil law jurisdiction, and other states are common law jurisdictions. So words you're used to hearing, especially if you go on the internet, dealing with leases and renting property, are going to be landlord and tenant. That's commonly what people call them. And I may use those words as well. But if I slip up and use the civil law terms, I don't want you to get confused. So in Louisiana, we talk about lessor and lessee, which is landlord and tenant. Comes to the same thing. But if you hear me talking about those two, that's what's going on. So we're going to be talking about these main issues in residential leases. I'm not going to be talking about agricultural leases. I don't think that's what you came to hear about anyway. And I'm not going to be talking about commercial leases. If you have a business, those sort of leases have different rules for them. So we'll talk a bit about your lease. It may be written down, it may not be. We'll talk about that. We'll talk about your rights and your obligations, both as a tenant or as a landlord, if we have some landlords on the call. We'll talk about how to get repairs made, what to do if you're going to be late on your rent or you're already late on your rent, how evictions work, how to get your security deposit back. And then toward the end, we'll touch on some fair housing issues, housing discrimination issues, and give you some resources to follow up with if you should run into one of these problems or you have one of those already. Finally, we'll try and leave enough room at the end for some of your questions. So that's the game plan for the presentation this evening. So as I promised, let's start off talking about your lease contract. Your lease can be oral or written. Verbal leases are legal in Louisiana. But think about why you might not want to have a verbal lease. If you and your landlord get along fine and there's never any problem and you live there till you die or you move voluntarily, that's not a problem. That's not the sort of stuff, though, that you're going to end up going to legal aid for some help with. The problems come when there's some dispute between you and your landlord. And when there's a dispute, you can't trust either side to tell the story without a little bit of embellishment to make their side look better. And it's hard for a judge to figure out who's telling the truth, especially if it's a verbal lease. If your landlord told you something verbally about the lease you were entering into and you didn't write any of it down and you go to court, you shouldn't expect that the landlord or the tenant is going to say, "Oh no, judge, I'm wrong. The other side is right." That's not going to happen. And the way to avoid that sort of a swearing match when you get in front of the judge is to write it down. So at the very minimum, if you're going to go down the street and rent a garage apartment for some nice old man or little old lady, jot down on a piece of paper the names of the parties, the name of the landlord, your name as a tenant, what is being rented, the address of the property or the apartment or the house or whatever it is, how much you're going to pay in rent, and how often you're going to pay that. Is it monthly? Is it weekly? Is it a 6-month lease, a 1-year lease? And then for how long you're going to be there. So a simple piece of paper, John Brown rents to Amy Tenant the property at 401 Any Street in Lafayette, which is where I am right now, for the price of $500 per month for a 6-month lease. A simple piece of paper like that makes it easy for a judge to understand what was the original agreement. Both of you should sign the piece of paper. Each of you should keep a copy of it. That means if you have to write it all down twice, that's fine. But that way you have a copy, they have a copy. A lot of times where disagreements come is when only one party has a copy of the document, like a lease, and the other side's trying to get it because it would help them. And all of a sudden, it miraculously disappears and they can't find the original contract or lease. So both of you should get a copy. If you're going to a large apartment complex and you're renting a unit there, be sure you walk out of that office after you sign the lease with a copy of the lease that has both signatures, both yours and the manager or the owner or the landlord. That's one way to avoid problems later on in court. The lease that you sign is just one of the rules you have to follow if you're going to be renting property. There are also local rules, state rules, and federal rules that are going to govern your occupancy of that property. Many towns, cities that are incorporated larger usually have some sort of city health or housing codes. That could be something that says to rent property, the property must have running hot and cold water. To rent property, it must have an appliance where the tenants can cook food. To rent property, it must have working plumbing in the bathroom. Those sort of rules aren't going to be in your lease. They're not in Louisiana law someplace. They're going to come from a city code. And so you need to be aware of those, both from the landlord's point of view to make sure that you're following those codes, but from the tenant's point of view as well to know where you can turn to for help if some of those things stop working or aren't working when you move in. Next level up from local sort of rules would be state uh, substantive and procedural rules. The most of the things we're going to talk about tonight about the rights you have as a landlord or the rights you have as a tenant come from state law. Very little of that comes from a local code. Very little of it comes from any federal rules. Very little of it comes from your lease. It's mostly in state law, in Louisiana's civil code. I mentioned earlier, we have civil law here, and that's because we follow a civil code. It's a big, long list of all the rules about all the relations people could have with one another or with property. There's also a separate code, and that one just deals with procedure. And we'll talk about a little bit of that when we talk about how evictions work, because that's where procedure really comes into play mostly with landlord-tenant law. Finally, at the highest level of stuff that really rarely comes into play are federal laws. That's things like fair housing. We'll talk about that before we finish this evening, and subsidized housing regulations. If you live in public housing, if you have a Section 8 voucher, if you live in Department of Agriculture rural rental housing, then those programs have federal laws that govern them. And they give you additional rights that a regular tenant in Louisiana wouldn't have. Those things might be additional protections for the tenant, additional obligations for the tenant, like reporting your income to the landlord periodically. So just know that local rules, state law, federal law, all apply to your lease. That you won't come into contact with them very often, but when you do, you need to know that they're out there. Finally, the last source of rules you got to follow is whatever goes into that lease. Your lease is what creates the rights and obligations that we're going to talk to. Before you sign a lease with someone who owns property, they owe you nothing and you have no obligations to them. When you sign that lease, it creates in each of the two parties, the lessor and the lessee, the rights that come from that contract of lease and the obligations that go along with that contract. So state laws, federal laws, local laws and regulations, and your lease contract. That's the source of all the law that needs to be resolved whenever you have a question about your lease. That's where all of that comes from. If you've got questions, as Rachel mentioned, just put them into the chat or put them into the comments if you're on Facebook, and we'll get to as many of those as we can toward the end. Let's start off with the rights of the landlord. The landlord's main right under Louisiana Civil Code is to receive the rent for the use of the property. The landlord can have either rent or possession of the property, but he can't have both. Once the landlord signs the lease with you, he has sold you the right to possess and live in that property. He doesn't have it anymore. It's not his, unless someplace in the lease he's reserved some part of that. Rent, we're going to talk a little bit more about rent when we talk about late rent. The landlord has the right to dictate, for the most part, the lease terms. If you're going to rent someone's house or like a single garage apartment, you have some flexibility in negotiating with them about what the terms of your lease are going to be. But as you know, if you go to an apartment complex with, hundreds of units, they're not very willing to negotiate with you over any of the terms other than how long you're going to stay there. They aren't too interested in negotiating the rent or what date the rent is due. They're going to hand you a piece of paper and it's take it or leave it. But the landlord has the right to do that in Louisiana, and the limits on what they can put in the lease are up to their imagination. They can put in there whether there will or won't be late fees, how much the late fees are going to be. They can put in guest policies saying you can't have loud guests after 10 p.m. They can put in provisions on who pays repairs. We're going to talk about repairs in a little while, but if a landlord puts in the lease, tenant shall pay for all repairs, and you read that and you sign that, you're stuck for paying all the repairs instead of the usual rules that apply in Louisiana. Um, the landlord has the right to terminate the lease if you break your lease contract under certain other circumstances, like if a hurricane comes through this season and destroys the property, the landlord can end the lease. There's nothing left to rent. Uh, Even though you have a lease that says you could stay there for another 6 months, if the property is destroyed, the landlord can terminate the lease. Um, I'm trying to think what else. Right of entry. Landlords have sold you the right to possess the property. But if in the lease they say, I keep the right to come into the property once a month for inspection, or I keep the right to come into the property to make repairs. If you see something like that, you should try and get some sort of provision that says how much notice you get. I've had cases where someone's in the shower and the landlord's maintenance man just comes in to make some repairs, and you really don't want that to happen. You want some sort of advance notice. You can give up your right to notices in your lease. We'll talk about that in evictions. Ordinarily, you can't just get an eviction notice from the court. Your landlord has to tell you first, I want you to move out. I don't want to rent to you anymore. But you can give up that right. And more, especially commercial uh, landlords for apartment complexes, are putting in a provision where the tenant gives up their right to those notices. And you really don't want to do that if you can avoid it at all. Finally, right of entry. The landlord's given up the right of entry, but read the lease to see if you're giving them the right to come into that property. The landlord has the right that to enforce your obligation to be a good caretaker of the property. If you notice water leaking through the ceiling and there's an apartment upstairs, you can't just be quiet if it's not bothering you. You have to let the landlord know about that. That's what a prudent person, a responsible tenant would do that. If your kids throw a baseball through the window, you have to let the landlord know, my kids threw the baseball through the window, so that he can make the repair and take care of his property. Finally, one that doesn't come into play very often because people don't know about it. Your landlord has a privilege, which is kind of like a mortgage or a lien, over your belongings. If you're having trouble paying your rent, and so you pack up in the middle of the night and you skip out on the rest of your rent obligation and go live someplace else, if your landlord can find you, he can chase you down and seize some of your belongings to get his rent back, which might be a car, it might be your big screen TV, it might be the kids' PlayStation or something like that. So the lessor has a privilege over your belongings to secure payment of his rent. And we'll talk about what to do if you're not able to pay your rent. Those are basically the rights that the landlord has. He can have rent or possession. He can dictate the lease terms. He can have you act as a good, responsible tenant. And he's got a privilege over your belongings to make sure he gets his rent. The flip side of that would be the rights that the tenant has, or the lessee, as I'm using both words. I'm going to pause a second, let the Facebook screen catch up. All right. The tenant or the lessee has the right to the exclusive use of the property. As I mentioned, the landlord sold you the right of possession. You own the right to possess that property, not him. And that means unless he's put it into the lease, he has no right to come into your apartment until the lease is over. You can just say, no, I'm sorry. I paid my rent. You can't come in. They're not going to like that very much. They're going to be looking for a reason to retaliate against you, but it's your right to have exclusive use of the property. You have the right to maintenance, which means if there is a repair that is necessary, the landlord has to make that repair. You have the right to peaceful possession. Now, that one gets a little bit more complicated. If your next door neighbor is playing their tuba at 3 o'clock in the morning and keeping you awake, that's not just your problem. That's the landlord's problem. Because you didn't go to the office and say, hi, I'd like to rent a very noisy apartment where I can never sleep peacefully. No, 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 that's not what you expected. You expected a place where you could get a good night's sleep. So if something like that happens, if there's a disturbance to your possession, to your peace and quiet, you go to the landlord, you explain what's happened, you ask them to do something about it. Many landlords will tell you, I don't care, call the police. That's not an acceptable answer. Sure, you can call the police, but your landlord's breaking his lease if he's not going to do something about it. That's if it's one other tenant, someone else who the landlord is renting to, has a landlord-tenant relationship with them. If it's just someone who's coming off the street and running up and down the parking lot in a very loud car at 3 o'clock in the morning, they don't live there. That's not your landlord's problem. That you can call the police about. You can ask your landlord to do something about it, but your landlord doesn't have to try and figure out who that was who trespassed on the property and is causing you a disturbance. Another right that the tenant has is to end the lease early. If your landlord violates the terms of the lease, for example, you go to him about the neighbor who's making noise, he doesn't do anything, he doesn't do anything. Legally, you can terminate your lease and move someplace else if you want to. And you're not breaking your lease and you're not violating your lease and you don't owe rent for the rest of the period after you move out. You can also end the lease early, just like the landlord can, if the property gets damaged. If the property is totally destroyed, your lease is over. There's nothing left to rent. But if it's partially destroyed so much that you really can't live there, you may be able to get a rent reduction, which the law says you're entitled to, or you may decide it's going to take too long for him to make the repairs. I'm out of here. And you can end your lease early if you want to do that. I mentioned earlier that you had some additional rights if you live in public housing or if you got a Section 8 voucher. That and all those kinds of housing where the government pays part of your rent. I'm going to call them just generally subsidized housing because there's a subsidy. You're not paying the full market rent that someone else might have to pay. If you live in subsidized housing, you have some additional protections. For example, I mentioned if the landlord wants you out, he's got to tell you he wants you out. Well, in Louisiana, you may only get 5 days notice that your landlord wants you to move. But in subsidized housing, you're going to get significantly longer in most of those federal programs, maybe as much as a month before you have to move out. If if you're renting from the nice old lady down the street and you get into a disagreement with you, she can tell you, I don't want to talk to you. And that's her right. She doesn't have to talk to you anymore. But if you live in subsidized housing, they don't have that right. Especially if you're renting in a public housing authority, there are grievance procedures where you can force the housing authority to sit down and talk to you and try and work out the problem. So just remember that if you're in some kind of subsidized housing, you've got additional rights more than what we're just going to talk about this evening. The flip side of all these rights, rights of the landlord, rights of the tenant, are the duties that both of them have. And they go along with what we were just talking about. So, starting with the landlord, when you move in the first day, the landlord has to give you the property in good condition. It has to be not in need of any serious repairs. It has to be clean. If it's not, he's breaking the lease at the very beginning by not delivering the property to you in good condition. The landlord has to give up one of his duties, give up exclusive possession. He has to understand he doesn't have the right to keep coming into your apartment or your house anymore. As we talked about disturbances, he has to maintain the tenant in peaceful possession. And that's against anyone else who lives in the property, who has a right to live there, who the landlord is renting to, but not against strangers, trespassers. The landlord has to maintain the property, and the language that the Louisiana law uses is necessary repairs. If your kitchen drawer is sticking, it would be good that it doesn't stick, but a judge is not going to make a big deal about that or think that that's a terribly necessary repair. If you're renting a furnished place and the refrigerator doesn't work, necessary repair. The stove doesn't work. The plumbing doesn't work. There's a hole in the roof. Those things are necessary repairs, and your landlord doesn't have any option unless you agreed to something else in the lease. Your landlord has to make necessary repairs and maintain the property. There may be other duties that the landlord has, which would be written into the lease, like a lot of apartment complexes say the landlord will take care of mowing the grass. That's not your obligation. That's the duty now of the landlord, but it's only his duty because it's in the lease, not because the law requires him to cut the grass or haul the trash away. If there's a big dumpster outside and you're supposed to bring your garbage there, your landlord may have said, he takes on the duty of getting the trash hauled off the property. So you have to look in your lease to see what other sort of obligations or duties your landlord has. On the other side, looking at it from the tenant's point of view, you have an obligation to pay the rent. The law in Louisiana, the main thing a tenant has to do is pay the rent. It has to be paid in full and on time. Partial rent is not paying your rent. 1 day late is not paying your rent. If either of those things happen, you've broken your lease, your landlord can evict you, and a judge is probably going to go along with him unless y'all work something out. Not you and the judge, but you and the landlord. Paying the rent is your primary obligation, your duty as the tenant. Second, and we hinted at this earlier, you have to be a good caretaker of the property. You have a legal obligation written into Louisiana law to timely report any damage to the property, regardless of what caused it. Uh, Hailstorm, tornado, your kid threw the baseball through the window, something, the toilet just quits flushing. You have a legal obligation to report that on time. And if you think about it, that makes sense. Some problems, once they happen, that's it. The problems happen. The stove doesn't light. Okay, that needs to be fixed. Other problems get worse the longer they are. I mentioned earlier as an example, you see water coming through the ceiling from the upstairs apartment. That will only get worse the longer it goes. So you have an obligation to report that as soon as you notice it. Same thing with holes Anything that's going to get worse over time, the judge is going to expect you to report it a lot more quickly than something that's merely an inconvenience. Another part that goes along with that of being a good caretaker of the property is that you have to tolerate whatever repairs are necessary. So if there's a leak coming through the ceiling and it's down the wall and the wallpaper's peeling or the paint is peeling and there's mold starting to grow, if you have to move out of that unit long enough for them to fix those problems, the law says you have to move out of that unit long enough for them to fix that problem. If it's inconvenient because they have to come in and change some flooring, that's tough. You have to put up with that inconvenience. The Louisiana law is very clear that you have to tolerate that inconvenience for the landlord to make necessary repairs. Now, if he hasn't repainted the unit in 50 years and he decides he wants to repaint it, that's a whole different matter. Unless you want to work with them about scheduling that, they probably can't force you to get out or let them in to repaint if they've been ignoring it for that amount of time. Another one of your duties is like in a china shop, you break it, you bought it. If you cause the damage to your unit, you're on the hook financially to repair that damage. The landlord's going to say you caused it, maybe, and you're going to say you didn't cause it. So the more evidence you have, the more things you can show him, the more promptly you report it, the better your chance of getting the landlord to fix it on their nickel as opposed to on yours. And then finally, you can only use your house for a house. You can't start running a business out of your unit. Most leases say that, and Louisiana law backs them up. If you're renting a residence, it's supposed to be a residence and not a place of business. All right, while we were talking about repairs, would probably be a good time for me to mention how to get repairs made. What a lot of people do is they see the maintenance man walking by outside and say, hey, my toilet won't flush. Could you do something? The maintenance man then goes to take care of the air conditioning unit or whatever he was planning to work on. He's not really paying any attention to what you say. And then you're aggravated because the problem didn't get fixed. You go to your landlord, and he doesn't know anything about it. The maintenance man never told him. Same thing if you go to the office. If you go to the office and say, hey, um, two of my burners are out on the stove. I need y'all to fix it. And then you leave, they may or may not remember that you came in, but one thing is pretty sure: if you show up in court with a lawsuit about this and you say, I told them the two burners didn't work, you should not expect the manager to say, oh, yes, judge, she told me the two burners didn't work. I just didn't want to fix it and I ignored her request. Don't expect that to happen. So, to get your repairs made, these work better the longer your lease is. If you have a month-to-month lease, it's going to be hard to enforce these rights. But generally, here's what you should do. Start at the very beginning by keeping notes. What date, what time, who was there when you reported the problem. Get a little notebook and jot it all down. The date, the time, who was there, any witnesses who saw you report it. Then put your request in writing, keep a copy, and give the written request to the landlord. Now you've got a note about when it happened, how it happened, and a copy of your request. If you show up in court with that, the judge is going to believe you and not the landlord who said, she never asked me to make any repairs. Then you need to wait a reasonable time after that. Kind of like the stuff we were talking about. Sticky kitchen drawer, you can wait a week or two. No gas, no water, no plumbing. You can't wait a week or two. If the refrigerator goes out, you've got young kids, even if you don't, there's no place to refrigerate your food. Those things are urgent, and you shouldn't wait more than a day or two before following up and saying, hey, everything in my refrigerator is spoiling. I can't give my kids any milk until you get this fixed. But you have to wait a reasonable time depending on the circumstances. If they won't make the repairs after you've gone to the office and requested it, given them a written request, followed up, and when you followed up, you put the notes in your little notebook, then the law in Louisiana gives you the right to have those repairs made and deduct the cost from your rent. So the first thing you'd want to do is get bids so that you can show a judge, if it comes to that, that you are acting reasonably. So for example, the tube or all the burners on the stove don't work. You can't cook at all. Once you've done those other steps and you've documented all your requests, you can call a plumber to come over and figure out if it's a gas problem or an appliance problem. You might want to call a couple of them and ask, what are you going to charge me to come out and do a service charge? Keep copies of that or put it in your notebook. I called this plumber and this plumber and this plumber. Put all that. Once you pick one that seems competent and is a reasonable price, you pay that price. You can't overpay. And then when the next month's rent comes due, you would uh, attach a copy, not your original, of your receipt for that work to whatever you still owe and give that to the office. So for example, if you owe $1,000 a month in rent and it costs you $300 for the plumber, you would pay $700 for your rent and the receipt for the $300 you paid the plumber. Your landlord is not going to like this, but he breached your lease. He's the one who didn't make the repairs that were necessary in a reasonable time, and you did what the law allows you to do, but expect there's going to be some retaliation. They're going to be looking for any reason they can to evict you. They can't evict you if you followed the law as I've just described it. That you didn't break your lease. They broke the lease. But if you have a month-to-month lease, they can decide they don't want to rent to you anymore. If it's a 6-month lease, at the end of the 6 months, they can decide they don't want to rent to you anymore. So think about that cost before you get into that problem, especially if you have a subsidy for your rent. If you're paying $80 for a 1 or 2 bedroom apartment right now, that $80 rent is extremely valuable to you, because if you end up out on the market, you're going to pay 10 times that for the apartment. So it may be worth just sort of going along to get along if you want to preserve that subsidy. So that's worth thinking about. All right, I promised we would talk some about late rent and what to do about late rent. So maybe we should talk about that now. The time to talk with your landlord about late rent is not when you're in court on an eviction. It's not when you get the papers from the landlord saying notice to vacate. The time to talk to your landlord about that is as soon as you know you're going to be late. Yeah, I mean, you can hide and hope they don't notice that you forgot to pay them. You can wait for that eviction notice, but none of that is going to be to your advantage. Best thing, go talk to the landlord. Say, hey, I just got laid off. Tomorrow I'm going to be seeking new jobs, but I want you to know I may be a little bit late with the rent because um, I got laid off. I don't have a paycheck coming in every 2 weeks like I used to. Your rent is going to be late at midnight on the date it's due. A lot of leases say your rent is due on the first. So at midnight, when the first turns into the second, if you haven't paid your rent, it's late. You've broken your lease. Your landlord can evict you if he wants to. Your landlord doesn't have any duty to take partial rent or late rent. If you get laid off and you talk to your landlord and he says, tough luck, pay the rent, and you go offer him half the rent or 3/4 of the rent or $1 short on your rent, he doesn't have to take it. He can say, I'm sorry, that's not what our contract says. You didn't agree to pay me half. You agreed to pay me the whole amount, and they can refuse to take it. Same thing if it's late. If you're there on the second and you offer them all the rent, if they want to get you out, they can refuse to take it. In my experience in 40 years, landlords don't evict good tenants. If you have a good history of paying, if you're working with them, if you're talking to them, not hiding, if you're showing them that you're trying to pay all the rent as quick as you can, most landlords will want to keep you as a tenant rather than have to turn the unit over, find another tenant to move in, go through all that hassle. So keep that in mind as well. All right. Whether your landlord charges you any late fees or decides to accept late rent is entirely up to them. Your lease says when your rent is due and how much it is, and they don't have to take anything other than that. Some of them will want you to sign something if they do take late rent. If your landlord continuously takes late rent from tenants, then he could, in effect, under the law, be changing your lease, where your lease is no longer due on the first. So most landlords won't do that. If they do agree to do it, they may want you to sign something saying you understand this is a one-time thing. Your rent is still due on the first of every month. Okay, let's talk about evictions. If everything goes south, uh, you made the repairs, you paid for them, you turned in the receipt, your landlord's ticked off, and at the end of your lease the next month, he says, I want you out of here. I'm going to send you a notice to vacate. Before you can get evicted, there has to be one of two things happening. Either your lease has to come to its end, or you or the landlord have to violate the lease. Until there's a lease violation, until the term of the lease ends, the lease continues. If neither you or your landlord say anything and it's a month-to-month lease, at the end of the month, the lease just rolls over. It's called reconduction. It just starts for another month. If you have a 6-month lease, you don't give any notice you want to move, your landlord doesn't tell you to move out. At the end of the 6 months, your lease is going to reconduct, going to renew on the same terms for another 6 months. If your landlord wants you out, unless in your lease you said, I don't want any notices, surprise me, you're going to get a notice to vacate. The minimum time you can get in Louisiana is 5 days notice to vacate. Like I said, unless you waived it. And in subsidized housing, you can probably get longer than 5 days, especially with a public housing authority. The landlord is going to wait 5 days. On the sixth day, the landlord can go to court and file a lawsuit to evict you. The court is going to send you a copy of all of that. It's going to be a citation and a summons saying, here's who's suing you, here's what they want, here's when you need to come to court. The trial could be as soon as 3 days after you get the court papers. The law says 72 hours, so 3 days, which means if you add it all up, your landlord can give you a notice to vacate. 5 days later, you have to be out. On the sixth day, he goes to court. Could be as soon as the next day you get papers from the court. So in a week and a half to 2 weeks from notice to vacate, you could be in court and the judge ordering you to be evicted. In court, you'll have the right to ask the landlord questions. You have the right to call witnesses, to introduce evidence. You have the right to raise your hand and swear to whatever facts you think would be a defense to the eviction. And then the judge is going to take all that into account and make his decision or her decision. If the judge says that you're to be evicted, that's not the end of it. There are rights to appeal, but you have to do something if you want to have that right to appeal. When you get the paperwork from the court, you have to file papers in response. You have to file an answer to the lawsuit about your eviction saying what your side is, why what your landlord said in the answer is not true. You have to sign that under oath. That means in front of a notary, and you got to file that with the court. If you file an answer under oath with defenses in it, then you have the right to try and take an appeal if the judge rules against you. If you don't do that, you have no right to appeal. If the judge rules against you, 24 hours later, they could enforce that eviction. They can call the sheriff or the city marshal or the city police to come out and physically remove you and your belongings from the property. And they will put it all at the street. And it's up to you then to find some way to get it to someplace safe if you want to protect your property. When you get a notice to vacate is the time to start thinking about what if this goes wrong. Don't wait until the judge is banging the gavel saying, I order you evicted. When you get the notice to vacate, make a plan. If I go to court and if I lose, uh, and if I have to move, what am I going to do? Start making some plans. Family, friends, someplace else that you can rent, and how are you going to move your stuff? Who do you know who's got a truck, a pickup truck, something that you can move all your stuff in? Think about it then. Hopefully you won't need it. Hopefully you'll win. The judge won't evict you. But if he does, you'll have a plan in place so that you're not frantic the next day trying to scramble to find some place for you and your family to live. Your appeal is going to have to be filed in 24 hours from when the judge bangs the gavel saying, I order you evicted. You've got 1 day to take your appeal. During that time, the judge is going to make you post a bond. If the fight is over your rent and you owe $800 in rent, the judge is probably going to make you post an $800 bond so that if you lose your appeal, your landlord doesn't lose any money. And if the appeal takes months, then probably every month you're going to have to go to the courthouse and put down another $800 so that if you lose, the landlord goes back to the court and collects all those $800 payments for each of your month that you didn't pay your rent. Okay, that's evictions. Let's talk about, what did I promise you? Security deposits. Talk about security deposits a little bit. The way to get your security deposit starts the day you move in. That's how you get your security deposit back years later when you decide you're going to move out or you get evicted. There's different kinds of deposits. You may pay a deposit to secure your payment of rent. You may pay a deposit against damages so that when you move out, if it's damaged, the landlord takes that deposit. Some places allow pets. You may have a separate pet deposit. So it kind of depends on what kind of deposit it is. Just know that when you're reading through that lease before you sign it, the deposit doesn't mean that you can just leave and the landlord's going to take the deposit and everybody walks away free and clear. That's not really how it works. If you pay a damage deposit, but you leave owing rent, they can still come after you for the rent. As I mentioned earlier, they can go seize your belongings to get their rent. So when you move in, first thing, read the lease. If everything looks okay, if you want to rent there, then you should insist on a move-in checklist. Apartment complexes do this naturally, but if you're just renting a house from someone, a lot of times they won't have one. So you make one. You go room to room, preferably with your landlord or the manager or the owner, if that's what it is, and you note room to room everything you see that's wrong. Because at the end, anything that's wrong, the landlord is going to say you caused. So you're going to want to mark nail holes. You're going to want to mark discolored walls, warped flooring, anything like that. You mark down on that checklist, room to room. Take pictures. Almost everyone's got a cell phone that takes pictures now. Take pictures of everything that you see. And if you don't see anything, take pictures of the whole room. Just so that if there's a dispute later, you can show those to the judge and say, this is what it looked like when I moved in. The carpet was already having a big stain right there by the kitchen, whatever. Um, you should both, if you can get your landlord or the manager to go along with you, keep a copy of that move-in checklist. Tell them to put it in your tenant file and you keep your copy. We talked earlier about damages. If anything does get damaged while you're living there, report it promptly. Repair any damages you cause. Let the landlord know when you report the damage. Hi, um, I spilled grease on the floor and there's a burn spot. Do you want me to have someone come and fix it, or do you want to have your people come and fix it? And if they want you to fix it, it's your bill. If they want their people to fix it, it's still your bill, but you don't want to just go off changing the landlord's property without their permission or without their knowledge. When you're ready to move out, that's the next time to see about getting your security deposit. You do the same thing you did when you moved in. You go to room, you note anything. You pull out the move in checklist that you have, and you compare your moving out to your moving in. You document everything in writing, what you see. You take pictures of everything you see that might be wrong. Because once you move out, you may not have access to that property anymore. The landlord may say, oh, we went in there and the carpet was all torn up. Well, if you've got pictures from the day you moved out and you made notes that the carpet was not torn up, then you've got a case. You've got something you can defend yourself with against the landlord's claims. Once you preferably you can do that move out checklist with the landlord or the manager as well. Then y'all can both agree, or you'll know right off y'all don't agree and there's going to be a fight over your security deposit. You give the keys back to the manager or the landlord and you put in writing, I am moving out on this date. This is my forwarding address. Please send me my deposit back. You keep a copy of that, you give a copy to them. Giving them that written notice starts a clock running. Under the law, your landlord then has 30 days to either refund your security deposit or to send you an itemized list of deductions they made for whatever damage they think you caused. If you have to sue to get your deposit back, there's a provision where you can get uh, I don't want to call it a bonus, but if they don't give you your deposit back or that itemized list within 30 days, you can get either $300 or twice the amount that they're withholding, not paying you. Plus, they'll have to pay your attorney's fees and the court costs if you win. So it's worth doing that and paying attention to that. A couple of other topics, then we'll take some questions. Fair housing. I promise we talk about fair housing for a little bit. It is illegal in the United States to discriminate against you in terms of advertising apartments, renting apartments, lease terms for apartments, any of that relates to your housing on the basis of your race, your skin color, your religion, your national origin, your gender, your sex, if you're a family with children, if you have a disability, all of those bases for discriminating against you are illegal. If any of that happens in renting the property, negotiating with the landlord, ads you see about what's available, the terms and conditions they put in your lease, you find out everybody who's of one religion gets one set of lease terms, you have a completely different set. All of that's illegal. And you can take those complaints to the Louisiana Fair Housing Action Center, to the state's Department of Justice, or the United States Department of Housing and Urban Development. They are all agencies that will enforce those fair housing protections for you. Okay, couple of resources, things that you can go to try and get some help. There are different kinds of resources. If you're just looking for information, you can go talk to lawyers. There's a wonderful website called Free Legal Answers. You type it all one word in your search bar and it'll take you right to it. The Law Library of Louisiana is a good place to look. Trying to think of some others that are really good. Your local pro bono project. Many of the larger cities in the state have pro bono projects. You can try the Modest Means directory on the state's website. State Bar Association has a website listing lawyers who've agreed to take cases for a reduced fee. You might want to do that. You can go to seminars like this for information. You can go to government offices, like I talked about subsidized housing. There are some self-help tools. One of the best ones are called legal navigators. You go to the State Bar's website and you can find a bunch of those where you answer questions and it gives you some guidance about what you can do. There's also a great website, again, all one word, Louisiana Law Help, and that's got great resources to help you. And then in addition, as Rachel mentioned at the beginning, there are some nonprofit law firms like Acadiana Legal Service, Southeast Legal Services, Fair Housing Action Center I just mentioned, and Disability Rights of Louisiana. Those are all available to help you get your information and some sort of guidance on where you're going. All right, that leaves us about 10 minutes for questions, maybe a little bit more. I saw some popping up. Uh, Rachel, you want to read off one or two?
Yeah, we've got a bunch of questions in here. Okay, the first one that came through was from Facebook. It says, I'm dealing with a situation right now. I moved into a place with rodents and a lot more problems. Instead of fixing them, they chose to take me to court and ask that I be removed. They're saying they don't want to stop until their voice is heard and that racism is a part of the equation.
Okay.
Um,
All right. So first on the racism, we just talked about that. If you can show that other people with rodent problems are getting treated differently and they have different skin color, different national origin, you might have a good claim for housing discrimination. Contact Louisiana Department of Housing, contact the United States Department of Housing, Urban Development, or here in Louisiana, the Louisiana Fair Housing Action Center. All of those would be good places for you to talk to about that part of the problem. Uh, if you haven't yet moved out, I think I talked about how to avoid this problem in the future or what to do to get it corrected if you're still living there. You go to your landlord, you explain what the problem is, you put it in writing, you keep a copy, and then the clock starts ticking. If you need to call the exterminator and they haven't acted in a reasonable amount of time, you can call the exterminator, pay the exterminator, take it out of your rent, but expect that they're going to try and retaliate against you.
okay. The next one is we've made multiple attempts to finalize a lease addendum that was verbally agreed to
Mm.
earlier in our tenancy, but never signed. This has caused ongoing confusion around rent deadlines, payment terms, and maintenance responsibilities.
Yeah,
With
well, that's
with
exactly what we
less
were talking about.
yeah, with less than 2 months left in our lease, we don't want to renew without a signed addendum in place. What can we do to ensure it's formalized before renewal? And if the landlord refuses, do we have any legal grounds to ask the court to enforce or intervene?
Okay, yeah, yes and no. You're going to kind of hate this answer. You signed a lease. That is the only lease your landlord has to follow until the end of the lease term. If you want to change the lease, you can ask, you can beg, you can cajole, you can offer additional money, but you can't force the landlord to change it. If you think you can prove the verbal contract, which we talked about at the very beginning, what the problem is with a verbal agreement like that, then yes, you could go to court and try and force the landlord to sign the lease addendum. Landlord's going to say, I never agreed to that verbally. No, I don't want to change the lease. And the burden is on you as the plaintiff to prove that that's what happened. The more witnesses who heard him agree to that verbally, who don't live with you and aren't interested in the dispute, the better your chances.
Okay. So another question. If a lease includes a 5-day grace period after rent is due, but the property manager applies late fees early, i.e. on the 29th, or issues 5-day notices before the grace period ends, are those notices aren't physically delivered, are they enforceable under Louisiana law? And also, can a verbal policy like refusing partial payments or backdating the due date to change late fees override written lease terms if no addendum was signed?
Okay, so that's 4 or 5 separate legal questions. I'm not sure I'm keeping track of all of them. Let's start with the first one. Remind me, Rachel, what was the very
It's the
first
the
problem?
5-day grace
Okay,
period.
5 day grace period. If your lease says you have 5 days to pay your rent and after the due date, and no late charges will be charged and no notice to vacate will be sent, then yes, you've got 5 days. I've never seen a lease that said it like that. The 5 day grace period may be before they choose to evict you. I'd have to see the language in your lease to answer specifically. Um, Sending you the notice to vacate as soon as the rent comes due is not a problem. They're just protecting themselves. It doesn't cost them anything except the sheet of paper they put the notice on. So they do that to speed up the eviction process in case you don't pay the rent when it's due. So they could send the notice to vacate early, even though you haven't breached the lease yet, and try and get that 5 day notice period running. What was the next issue in there?
So, can a verbal policy like refusing partial payments or
Okay,
backdating the due
right.
date to change late fees earlier
Okay,
override?
so we talked about the verbal part, right? Your landlord has no obligation to take late rent or partial rent, none. If you pay only partial rent or you pay late and your landlord tries to evict you, you can file an answer saying, my landlord verbally agreed to take my rent late or to take partial rent, and good luck proving it. Your landlord is not going to say they ever agreed to that. There was one or two more issues in there, and I don't want to cut off. We've still got some time.
Well, they were saying, yeah, does that override written lease terms if no addendum was signed?
Yeah, if you can prove it, yes, you can have a verbal agreement in your lease. You can have a verbal addendum that says, we won't charge you late fees, we'll take late rent, we'll take partial rent. If you prove that that agreement happened, then yes, that's a change to your lease. Doesn't have to be written. Louisiana doesn't require leases or addendums to be written, but you've got to prove it if you're the one who's saying that's what happened.
Gotcha. All right, next question. Do I have a viable civil case against my former landlord or apartment complex for damages related to uninhabitable conditions that led to displacement, financial loss, and potential
Okay.
breach of lease obligations? Our move out date
Yes.
was April 2023.
Ooh, okay, two answers. I'll take the last one first. You generally got 2 years to bring a suit for damages in Louisiana. If that was April 23, we're past 2 years, so you probably are time barred. The legal word lawyers use is prescription. Your claim is probably prescribed. The best time, now the first part of the question, the best time to bring those sorts of claims is while you're still living there. Once you move out, then the judge is going to be looking askance at your claim, saying, well, why didn't you say anything earlier? Why did you wait a month, 2 months, 2 years after you moved out to bring your claim? So while you're there is the time to bring those claims. And we talked in the main part of this presentation about how to get repairs made.
Okay. Next question. Can an eviction from 2019 be challenged?
If you mean appeal, no. Your appeal deadlines have run. Generally in Louisiana, you've got 30 days to take an appeal that might suspend the operation of a judgment. As I mentioned earlier, you've got 24 hours to take an appeal from an eviction. And there are other kinds of appeals that would not stop you from being evicted, but you might win eventually. Those are called devolutive appeals, and you got 60 days to file those. But no, it's way too late to challenge that eviction.
Okay. Let me see. Got a few more questions, Greg. Let's
Sure.
see.
We have time.
Um, okay. Can you repeat the 5 day rule for eviction?
Okay. In Louisiana, if there's nothing different in the lease, if it's not subsidized housing, your landlord must send you a notice to vacate unless you waived it in your lease. And that notice must give you no less than 5 days to move out. It's called a 5 day notice to vacate. During those 5 days, your landlord can't legally go to court and file a suit against you. Your landlord can't throw your stuff out. Your landlord can't turn off the electricity or the water or the gas. He has to wait those 5 days. On day 6, the only right he has is to go to court and file suit against you. On day 6, he can't turn off your gas, your water, start moving your stuff out, change the locks. I've seen all of that happen, but that's illegal, and you have a claim against your landlord if that happens. 5 day notice to vacate.
Okay. Next question. I have a tenant renting a lot in a park, and tenant is filing bankruptcy on the trailer, but is still in it. She says she doesn't have to pay the lot rent because their lawyer told her not to. My understanding was as long as they are in there, they would be responsible for lot rent until they move out.
two separate questions. One, are they obligated to pay the lot rent? And the answer is yes, they're obligated to pay the lot rent. Second question, do they have to pay it? And the answer is probably no. When you file for bankruptcy, the court issues an automatic stay. It stops anyone from filing suit against the person who filed for bankrupt, from collecting against the person who filed for bankruptcy. When your tenant filed for bankruptcy, they had to list everything they own and every debt they owed, and they probably listed their lot rent as one of their debts. Depending upon what kind of bankruptcy they filed, you may still get paid your full rent, or you may get only partial rent. If you get only partial rent, once the bankruptcy is finished, you may be able to evict them. But while the bankruptcy is going on, there's an automatic stay that would keep you from filing a suit against them. And that's why their lawyer told them, until the bankruptcy is worked out, you don't have to keep paying your rent. Um, the way bankruptcies work, either a liquidation bankruptcy or like a budget, a wage earner plan bankruptcy, affects how much and when the landlord is going to get paid.
Okay. Next question. What is a reasonable amount of time for a landlord to respond to a maintenance request? We have notified our landlords of a hole in our front door that allows pests in, and they have not answered any of our texts or emails in 2 months.
Okay. I would think, my opinion, if I was the judge, a few days to a week would be a reasonable time. But every single situation is going to depend on its circumstances. Right now, I'm assuming this is not the case. Immediately after the bad hurricanes that we had a few years ago, you couldn't find a contractor, you couldn't find a carpenter. And so in that case, it could have been weeks or months before they had to fix the hole. Right now, that's not the case. There's no excuse. Even to come patch something over the door only takes a few minutes. So I think a reasonable time is a few days. I would not want to rely on text messages and emails. I would want a written request for repairs that you brought to the office, that you signed, and you ask them to sign saying that they received it, and then you kept a copy and they kept a copy. Then there'll be no dispute about, did you ask for the repair? When did you ask for the repair? What repair did you ask for? Text messages, you can try to introduce them. Sometimes there's problems. It's hard sometimes for lawyers to get text messages and emails into evidence because of authenticating exactly where they went. Your landlord may not admit to having received those things. They can't deny a letter that you delivered and you have a copy and you brought a witness with you. So,
Okay. Next question. What should I include in the contract if lessor is not sure, if he cannot keep the contract term? After lessor paid all the rent after the 5th of the month, what kind of fee should they have to pay?
what kind of fee should the tenant have to pay if they paid late? I'm guessing is what that question is. Does that sound like what they're asking, Rachel?
I think so.
Okay. So if the lease doesn't say anything about late fees, then the tenant doesn't owe any late fee. The landlord had the choice not to accept the late rent and instead to evict the tenant. But if they did accept the late rent, then the rent's been paid. They can't evict you for any period of time that the rent's been paid, and they can't charge you an extra fee unless you agreed in your lease that you would pay an extra fee, or the tenant agreed to pay an extra fee.
Okay. We got one more question. If the tenant signed a waiver of the 5 days, can the
Mhm.
landlord still place the 5 day notice when the rent becomes late?
Yeah, a landlord doesn't have to insist on all their rights. Like we were talking about rent, your rent's due in full on the date that it's due, not partial, not late. But if your landlord decides to take the rent 5 days late or 10 days late, they can do that. There's no law that keeps them from being kind to you. The same way, if the lease says they don't have to give you a notice to vacate, but they're kind and they give you a notice to vacate so that you know that they haven't broken your lease, they haven't done anything bad to you. It's a nice gesture on their part. A lot of apartment complexes, because they have so many tenants, it's all automatic. On the date that the rent is due, the next day notices to vacate go out, whether the lease says they have to give you one or not. So no, I don't think the landlord has done anything wrong. It does help the tenant to know, hey, it's serious. You need to go pay your rent.
And then one more question. Can you
Sure.
evict even if the landlord accepted partial rent?
Partial rent, yes, because remember we talked about what the tenant owes. The tenant owes rent in full on time. If you pay $1 short of your rent, you haven't paid your rent. You broke your lease, your landlord can evict you. So yes, he can take partial rent. Think about it from the landlord's point of view. Uh, Say you owe them $500. You come in and offer them $400. 400 is better than nothing. The landlord's going to want to take the $400, but that doesn't mean they give up their right to evict you.
Okay. And that's all the questions we have, Greg.
Well, that's right on
Um,
time. Y'all doing good.
Thanks. If you don't mind going to the next slide, I just want to talk
Sure.
about some of the resources. Greg's actually mentioned a lot of them. So first, I want to talk about our Find Legal Help access points. They're located in Lake Providence, DeRidder, Harrisonburg,
Hmm.
Faraday, and Chalmette. Basically, they are kind of standalone. They look like phone booths with a computer inside that will walk you through the steps and take you to every resource that Greg mentioned. So that Louisiana Law Help, the Civil Legal Navigator, free legal answers. We encourage you to use those access points. And if you want to know where they are, you can go to the Louisiana Civil Legal Navigator and find them. And if you'll go to the next slide, Greg.
All right.
So another resource, again, Greg mentioned for the most part all the resources on this page. This page is the Find Legal Help page on the LSBA's website. So if you have a legal question that was not addressed during this presentation, or you need help getting assistance, please go to this page. You'll find the Find Legal Help button on the LSBA's homepage, where you can access our attorney directory, the Civil Legal Aid Navigator, legal aid and pro bono organizations, the Modest Means Directory, and self-help services. I do want to flag one resource in particular on that page. It's Free Legal Answers, which is something Greg pointed out. It is an online pro bono program that allows users to log in whenever and wherever they like, ask civil legal questions, and have attorney answer those questions through the site. You do have to meet certain income guidelines, but it is a great resource out there if you have questions on landlord tenant issues or any other civil legal issue. And a great thing, if you have a lease and have a question about your lease, you can actually upload the lease through the site and have an attorney read it. So this is a great resource that talks about all the spectrum of services available throughout the state. And if you'll go to our next slide, Greg has put all the next dates for our upcoming law talks. The next one is Making a Will. It's going to be August 13th at 12 noon. Types of adoption in September. And then you'll notice in October, we have several, all the week of October 20th as part of Celebrate National Pro Bono Week. And then in November, we'll do public benefits and SSI. Please consider us joining us then for those presentations. Greg, thank you so much. We've had comments
Sure.
coming in about how great your presentation is. And
Oh,
thank you
thank you.
for being here this evening talking about
Glad to
these
do it.
important issues.
Glad to do it. Let me mention that those resources Rachel mentioned are written in English for real people, not legalese, so don't be afraid to use them. Go to the lsba.org website and look for those resources. They're great.
Absolutely. All right. Thanks so much, Greg. Everyone
All
have a good
right.
night.
Good
Bye.
evening.